seconds, so welcome. On a combien de personnes déjà qui sont connectées? Ok, donc ça c'est bien. À 30, on y va. Welcome to those who are already there. We will start in a few seconds. So, welcome to this webinar, or more precisely, the second part of the webinar. In fact, we already had a webinar on data protection in November on international data transfers. For those who weren't able to participate at that session, please note that the recording of that session is still available on the website of the ALJB under the members section. Welcome, my name is Peter Vermeulen. I am the Chief Legal Officer of Foyer Group, and I'm also a member of ALJB's board. The protection of our personal data is a fundamental right. Indeed, the EU Charter of Fundamental Rights has a specific article, Article 8, on the protection of our personal data. And this article of the Fundamental Charter of Fundamental Rights also says that there should be an independent authority who checks that these fundamental rights are respected. And therefore, we are very fortunate today to have a representative of the CNPD, because the CNPD in Luxembourg is that authority who checks that our fundamental rights in relation to data protection are respected. As Luxembourg citizens, we of course know the CNPD, but I think that since a couple of months, the CNPD is known worldwide, at least in business and legal circles. And why is the CNPD known worldwide? But because of the topic of today. And the topic of today, as you know, is the CNPD controls and sanctions. And the CNPD takes this competence very seriously, because the CNPD sanctioned Amazon in July last year to an amount of more than 740 million euros. And that is the largest fine that has been given in the history of the General Data Protection Regulation. However, the legal proceedings between Amazon and the CNPD are continuing before the Luxembourg courts, and it seems that Amazon seems to have won a battle, not the war, but a battle on some injunctions that the CNPD imposed on Amazon. This information seems to come from the press and maybe from the lawyers from Amazon, but the CNPD is more discreet, because indeed the CNPD is subject to a professional secrecy obligation. The lawyer of the CNPD is also more discreet, but reliable sources have said to me that the lawyer of the CNPD today would be present in our session. Before introducing the moderator of today, some practical matters. So the presentation will take about 45 minutes, and then there will be time for questions and answers. So if you have some questions, you are able already to ask your questions by using the button at the bottom of your screen at the YouTube link. both the slides which will be presented and the recording of today's session will be available on ALJB website under the members section. And of course, I asked the participants if they were okay with that, and that there will also be photos taken, because these participants take the treatment of their processing of their personal data very seriously. So finally, I would like to thank our host, Neta Dutil, today, and in particular also the speakers. Vincent, you will introduce the speakers, but I have the privilege of introducing you as the moderator. You are a partner of Nota Dutil. You're heading the IP, ICT, and competition departments, but of course, today you are particularly here because of your experience in relation to data protection law. Vincent, the floor is yours.
So, thank you very much, Peter, and ALJB. So it's an honor to host the second session. It's of the series of two. So the first one was on international data transfers. I think people can still watch recordings on YouTube. So depending on which angle you take it, but on my left-hand side, Michel Zinner from the CNPD, who is in charge of the investigations within the CNPD, if I put it shortly and correctly. And we will see further on that there is a distinction between the investigation and complaints, etc. So we will walk you through these procedures. And on my right-hand side, of course, the incontournable Stefan Omnes, DPO of Post, DPO of the year of 2019, if I'm not mistaken. So welcome, Stefan. And Stefan will also give some more also practical insight, his experience, how he deals with complaints and, as the case may be, some investigations. So I would like to take the opportunity to first present the procedure on the basis of a few slides. So thank you very much. Because that's always a good thing to have some kind of framework that you can rely upon. And of course, Mr. Zinner will also, after that, follow a bit the same framework and give some extra explanations on some of the sections of the procedure. So first of all, some stats, because until a few months, a lot of people asked themselves, yeah, we didn't see that many decisions from the CNPD. Even before July 2021, there were already a series of decisions with minor sanction amounts of in the range of sometimes 18,000 in one case, 1,500 in another case, and these cases were more related to the thematic audit on the role of the DPO, on which we will come back. But in 2021, in the beginning of 2021, there was a parliamentary question, and one of the members of parliament said, well, we don't see that much from the CNPD, and what is going on there? And actually, as you see from the stats, how many complaints the CNPD has to deal with. I think in 2019, it was over 600 complaints, so complaints that normally come from the physical persons themselves, so from the data subjects. And what we have seen there, that in the reply of the Prime Minister, who is also the minister that is in charge of the CNPD, that there was some corrective measures that were taken in 2020 in 167 cases on a national level and in 65 EU cases, because as you know, the CNPD is also what we call, in data protection terms, the lead authority for some bigger firms who have their headquarters here. It's another topic to explain what is a lead authority and what are the criteria there. But it's obvious that the CNPD is a lead authority for organizations such as Amazon, but I could imagine also well for PayPal and some other international players. And via that network, also 65 cases have been closed by so-called corrective measures. And we will come back in a minute to what that is, because it's not a final decision. And the final decisions, these are a bit more rare. And we have seen that there are 2 sanction decisions. If you see all the amount of complaints, only 2 sanction decisions came out of these complaints. So that means that a lot of them were resolved in another manner, and we will come back to that in a minute. The CMPD also runs some thematic campaigns, or some. There has been the thematic audit on the role of the DPO, or the Data Protection Officer. Stefan will certainly be able to tell something more about that. On video surveillance, that was another major topic, and there are already the first decisions that are coming out from that audit. Another big theme was COVID-19. So how did organizations deal and process personal data in that context? Another one, a very important one, also transparency. So whether the notices of protection of data, the data protection notices, are sufficiently transparent. So that will be a very interesting one. So now, when we turn to the procedure, what do we see in the middle? If there is a real procedure, an official procedure that is launched, it's always on the initiative of one of the members of the CMPD. What do I mean by members of the CMPD? The CMPD is a collegial body of 4 persons, and one of the members has to propose formally the opening of the procedure with a proposal to further investigate the case. Now, the way to that point, there are different ways in that respect. So there is a proactive way from the CMPD, so non-reactive, so that the CMPD will of its own motion take an initiative. And for example, the audit on the role of the DPO was such a kind of proactive approach, where the CMPD said, well, let's take 25 organizations, representative organizations in Luxembourg, and we will inquire them on the role of the DPO. What is very important in that respect is that from the moment that that audit was opened, there was already a formal investigation. Because maybe some organizations had in mind, well, there is a kind of thematic audit and with a questionnaire, and we will of course reply to it, but you must be aware that at that point there was already a formal investigation of the case. Okay. Then, as I explained, you have also the cooperation network within the EU, where for example, an Amazon case, if there is a complaint in Germany or in France, normally the local authorities have to transfer the complaint to the CMPD, and the CMPD gets then that complaint also via its network. And when we're talking about complaints, the CMPD has adopted a procedure on complaints, so under which conditions a data subject can bring a complaint. And the CMPD has also indicated how it deals with these complaints. And it was quite instructive because the CMPD explains in a very clear manner under what conditions a complaint is, for example, inadmissible. If you have a problem with a data controller to exercise your rights, you first should address yourself to the data controller to exercise your rights instead of immediately running to the CMPD. If you do it too early, your complaint will be inadmissible. The CMPD will also look at the importance of the case. The CMPD, Mr. Zinner, how many people are working at the CMPD, more or less? So 53. So if you see the amount of complaints, it's quite huge. So the CMPD also has to set its priorities, and we'll also pick the more important cases. And that's of course something that sometimes is criticized, but I think every enforcement authority has to set some kind of priorities. And on that basis, a complaint can be rejected. If a complaint is not rejected, it will be analyzed by the CNPD. And what can happen then, that the CNPD will already at that very early stage identify some problem points. And then it will offer to the organization a possibility to comply with these points, what we call then corrective measures, but it's the terminology of corrective measures is maybe not ideal, because at the end of a procedure, after an investigation, you can also have corrective measures. So sometimes there can be a confusion there, but we call them, let's call them here in this context, corrective measures. So then the organization has the possibility, do I comply with these corrective measures, with the suggestion of the CNPD to tackle the problem that has been identified on the basis of this first high-level analysis? And if the corrective measures are complied with, the case will be closed. Or if after analysis the CNPD says, well, actually the complaint is not founded, then the case will be closed at that point of time. However, if the organization does not comply with these corrective measures, or if the case is a very serious case that the CNPD sees from the beginning, well, there is no use to offer some corrective measures, this is really very serious, then of course it goes straight to the CNPD member, who will then make the formal proposal to further investigate the case. Then within 1 month, the CNPD, then in its collegial setting, will take the decision, yes, we open an investigation, and in that context, there will also be one of the 4 members of the CNPD will be appointed as a chief investigator. Why? Because then one of the 4 members will lead the investigation and cannot sit on the setting of the CNPD, what they call then restricted formation restreinte, who will eventually decide on the case. So you have the chief investigator, and then you have then the CNPD in its restricted setting that will decide on the case. The chief investigator will also have a kind of mandate, an ordre de mission, where his mandate is a bit more clarified, and it's also on the basis of that mandate that it can be shown to the controlled organization, that the controlled organization knows when the CNPD does some further investigation what the case is about. So that, and at that point you can already see that the rights of defense kick already in vis-à-vis the organization, because the organization knows then what it is about. So the investigated organization, so the controlled organization, will also be informed. It can also be that there is also an on-site investigation which is unannounced, and in that case, of course, the controlled organization will be informed at that point in time. Then there is a further investigation, and as I said, it can be an on-site investigation, there can be some audition, there can be also a request for information. So not in the case in the context of an on-site investigation, but just that the controlled organization will receive some questions from the CNPD. Well, small advertisement for the profession of a lawyer. Of course, if you deal the case then at that point of time with a lawyer, there's also this professional secrecy that comes into play between lawyer and his client. So there is like we have that in competition matters, because we know, of course, in terms of GDPR, there are a lot of consultants and advisors outside who advise at that time, but maybe if you have an investigation like this, it could be a good idea also for professional secrecy reasons to involve a lawyer. So that's just a small publicity for the profession, but that is the way how it is done, for example, in competition cases. Normally at that time you rely on a lawyer. So then there are some of these investigation measures, and it can be that at that time and there comes already from the investigation team a proposal to close the case. Or if the case is not closed at that time, there will be a statement of objections. It's very interesting to see as well that in terms of wording, there are so many similarities with the procedure in terms of competition law. Because in competition law, you have exactly the same wording, that if there are some grievances that come from the authority, they call it statement of objections. And to give a bit more structure to the discussion, in very important cases, you also see that there is a synthetic audit report that is drafted by the authority. If I may say so, from our own experience, we see that already at that level, there can be some interaction with the controlled organization, who will also have its say, well, this in the audit report is maybe not that correct, and normally at the end of the process you come to a situation where the audit report is a bit accepted by the controlled organization. That is ultimately the goal. Of course, if the control organization refuses everything, I imagine that you will anyway adopt the report. But we have seen in practice that the audit report is not necessarily so much on the legal side, but more on the factual side, so that everybody agrees what are the facts of the case, and are we talking about the same thing. And there can already be, that's also a phase, a very important phase, where the organization can already say something about the facts. And it should give also some comfort to the CNPD later on, that these facts are not contested or contestable. But from experience, we also know that sometimes they are contested afterwards. So then you have the statement of objections, with of course also an access to the file for the controlled organization. That access to the file is not absolute. There can be important exceptions to that. And then you get a contradictory procedure with the exchange of written observations from the side of the controlled entity, and also the chief investigator also has the possibility to answer to that. And of course, as the controlled entity is in that procedure, the defendant, and the defendant in the rights of defense always has the last word, the controlled entity has then the last word, so to say. And after that, the file will be transmitted to the CNPD. So then that's a point in time that the investigation is closed, and that we have a nice file to give to the CNPD. So if there is a proposal to close, the CNPD will either say, okay, we are fine with the closing, or will ask to send the case back to the chief investigator, who has then to review some of the parts of the homework. If there is a statement of objections, then the CNPD will handle the case, as I said, in formation restreinte, or in its restricted formation. That means without the chief investigator being there, will deal with the case. And in that context, there will also be an oral hearing, where the chief investigator can expose, of course, his view and the organization concerned. Question mark is there place for other persons? So it's not foreseen in the current procedure, in the current GDPR enforcement procedure in Luxembourg. For example, the data subject, who is maybe at the basis of the complaint, will in principle not be part of that oral procedure, because it's simply not foreseen. The GDPR foresees that the plaintiff who files a complaint is entitled to know about the outcome of the case, and of course the outcome of the case will be transmitted. So at that time, the person who filed the complaint will know what the issue is, and as the case may be, may or may not challenge that decision. For example, if there is a closing of the procedure. So after oral procedure, there will be a deliberation and then a decision. Decision on the basis of professional secrecy, in principle, is not published, but the publication can be also a measure of sanctioning, and it will only be published, of course, at the end of the procedure, taking into account also the pending appeal. So only if there is no appeal possible anymore, then the decision will be can be published. Of course, the CNPD wanted to give some insight into its decision practice, so that's the reason why, as we have seen, most decisions related to the DPO function are published, and you cannot see which entity has been sanctioned. So it is possible that some decisions are anonymized, But for example, in the case of Amazon, it would be difficult, I think, to anonymize the decision, and that's also the reason why it's not published yet. I think a lot of people have criticized that, but that's how it's, for the time being, it's organized. On the administrative sanctions. So, of course, everybody, that was a big game changer of the GDPR, of course, that before the GDPR, under the directive of 95, doing privacy for 20 years. 20 years ago, people would ask, yeah, but what is actually my risk that I do not comply with data protection law? And then as a lawyer, you had to say, yeah, not much. In any event, no fines, and then you see that had really an impact on how organizations reacted to data protection. Of course, one of the big game changers in the GDPR is that there is now an explicit basis to impose fines on organizations that are not compliant, and even up to 4% of the annual turnover, with the big discussion being, is that maximum of 4% to be assessed on a group level or not? So on the basis of some recitals in the GDPR, it would rather be on a group level. But if I'm not mistaken, that question has been referred now to the Court of Justice of the European Union in a German case very recently. So the Court of Justice will shed its light on that question, because it's very important, Stefan, also for Post, I think, many affiliates. So also processing data that if it's calculated on a level of Post Group or on the level of the turnover of the affiliate, I think it would make a rather big difference. So, but in the toolbox of sanctions, there are also some sanctions that are not, that we do not talk much about. There can be also a warning. For example, if the CNPD finds that there is an imminent violation of data protection law, it can also issue a warning, whereby the question is a bit under Luxembourg administrative law: is that actually a sanction that really puts a grief on, that really grieves a control organization? Is it sufficient to go to the administrative courts? That's an open question mark. As we said, publication of the decision can be a separate sanction. And also, I think that's maybe also a sanction that is not used very much, but would be very powerful, is right away to suspend or prohibit the processing. I think in many cases that would maybe a sanction that could hurt more than some fines. There can also be a compliance order, so which is, in my opinion, logic. CNPD establishes some violations. Under competition law, for example, it's a no-brainer that you have to stop the violation. So, unfortunately, in the GDPR, it's not put in this way in an explicit manner, but there is a measure that is possible that the CNPD can order then issue a compliance order also under penalty payments. And I don't think I tell a secret. That was also one of the aspects of the Amazon case, because the decision of the president of the administrative tribunal is public. So that is the it was one of the items was rather that there is a problem with potentially with the compliance order. So. Then there is also a possibility for rectification, erasure, limitation of data. Very quickly, so after a decision of the CNPD, you have an appeal before the Tribunal Administratif, and with another appeal, a second appeal that is possible before the Cour Administrative. What is very important in that respect is that it's an appeal in full jurisdiction. That means that the Tribunal Administratif can put itself in the place of the CNPD, because normally procedure before the Tribunal Administratif is an annulation procedure, where the court will look, did the authority its job? Could it render the decision at the point of the decision in that manner, and is it legal? Whereas if you say appeal in full jurisdiction, the Tribunal Administratif can look at the date of his judgment, can see, did anything change? And strictly speaking, the Tribunal Administratif can take that into account. For example, if the CNPD issues an order to comply with the GDPR, it can very well be that in the meanwhile, the organization that was controlled has improved some of its processes. Then it's perfectly possible for the Tribunal Administratif to take that into account at the day of judgment. But that we will see, of course, how the Tribunal Administratif reacts to that, because in a certain way, the court is forced to do, at that point of time, the job of the CNPD, or make the assessment of the CNPD. So that will be a very interesting point to see how the Tribunal Administratif will look at that, or whether it will prefer to say, well, actually, for us, there are some reasons to maybe send the case back to the CNPD. But it's very important to know in terms of procedure, that the difference between an action where you just can go for the annulment of the decision, or that you go for the Tribunal Administratif. Strictly speaking, it's not even excluded that the Tribunal Administratif can be a reformatio impeius. That means if you have a sanction, that it can even increase the fine. It would be exceptional, but not impossible from a legal point of view. And then there is a point that I also would like to stress, because of course we all know the CNPD and does a great job. But there are also other courses of actions that are possible. You can also enforce the GDPR before the regular courts. Yeah? Because if you take the parallel with competition law, in competition law you nearly inevitably you have to go via the competition authority, because some cartels are secret, for example. Now, in the field of GDPR, some violations are plain. If you see some data protection notice, you can see from miles away that they are not compliant. And then what could you do? In the end of the day, you could also bring the case before a regular court, which would have competence. And a court can have competence also at the place of where the data subject is. So for example, if you have problems as a data subject with Amazon, and you're a German resident, you could bring the case in Germany, and it would not go then via cooperation mechanism to Luxembourg. So that is possible as well, and it's also possible that in some countries you have a cessation order that you can ask in a kind of summary proceedings. We have seen that in Luxembourg there is also a case in summary proceedings where a bank was prohibited in summary proceedings to transfer data to the US. So that's also a case where GDPR enforcement worked via summary proceedings before the regular courts. You also can see that data protection notices can be considered to be a term within the contract with the customers. And you see in Germany and also in France that, that they can be considered as unfair clauses if they're not compliant, and that you have special proceedings on the basis of unfair clauses that via that manner you can actually also have some summary proceedings to, or as in summary proceedings to have, for example, data protection notices corrected. Also very important for me in terms of GDPR compliance, some clients say, for example, in the field of HR, yeah, we know that we are not compliant with our data protection, with the data protection regulation. But then I say, for example, in terms of monitoring of IT of employees, but then I see, then I always say, but normally what you do IT monitoring for, to collect proof. And if the proof is not GDPR compliant, you can, it may have consequences in a regular litigation, that you cannot enforce actually the proof that you were collecting. So that's also a very important aspect, I think, from a procedural point of view. And what some people just don't know, that if it's really contrary to the GDPR, that the database can also be illegal, and that the sale of a database, that the sale itself can be declared null. I think there is French case law on that, Supreme Court of France, that says, well, actually, if you sell a database that is contrary to data protection law, actually your contract of sale is actually null and void. So there are very interesting points to address, in my opinion, also before the regular courts. So CMPD remains, of course, one of the major pillars in terms of enforcement, but also let's not forget the possibilities before the regular courts. And in terms of some takeaways, so any organization that processes personal data can be subject to an investigation for any type of GDPR infringement, and any kind of information can be requested in that respect. Please bear that in mind. Impact of COVID-19 on on-site investigations, of course. It's maybe a point that, but now that probably was a bit put on ice, the on-site investigations, but now it's picking up again.
Out there, but less.
Yeah. As I also told, thematic audits are investigations. It's not just no strings attached questionnaire that you just say, okay, I will have a look at it and I reply to it without really thinking. So really consider it to be as a real investigation measure. And also, you must be aware that at the moment of the investigation, there is no judicial control at that stage. Contrary to competition law, where at that stage you have a kind of judicial control. You can call upon the president of the Tribunal d'Arrondissement at the time, who can do some checks on the investigation. That judicial control you don't have. Yeah. So that is the introduction of the procedure. And I have, of course, some questions to Stefan and Michel. So, Stefan, so as we see from the statistics, there were a lot of complaints filed to the CMPD, and most of these cases were actually closed before they got to the investigation phase. And what is your experience in that respect?
At Post Luxembourg and Post Telecom, we had in 2019 4 complaints handled by the CNPD. In 2020, we had 2 complaints files only to manage, and last year only 1 complaint has been processed by Post from the CNPD. So it's quite few, because Post is almost a very big company in Luxembourg. what we can see with that small files and few files, the underlying themes linked to this complaint were for Post focused on, first of all, security of personal data. Okay. We had one complaint linked to this matter. The customer was saying that third party accessed his data and it was the wrong thing for Post. After investigation and discussion with CNPD, we analyzed that the circumstance and the context of this special case was due to a third-party phishing attack. Okay. But it has been linked to our case because it was concerning also some data that the customer was thinking coming from Post. Second category of complaints were concerning the matter of exercise of rights. So both for a disagreement about how we answer the exercise of right, and one time we also had an incident with the delay we answer to the customer, and it has a consequence, a complaint to the CNPD. And last but not least, we also had to manage transmission of data to third party complaint because the customer was not understanding how the third party was processing the data coming from Post legally. Okay. And it has to be explained with more transparency to the customer. One of these few complaints associated with a data breach notification which is made to CNPD in 2019 resulted in a triggering of more in-depth investigation and the form of a formal control which has started last year and which is in progress.
Okay. So that was also, if you notice, one of the first slides, so that it can be a data breach notification. So you have the obligation to proceed to a notification of data breaches. And of course, when analyzing that notification, the CNPD can also come to the conclusion, can ask questions whether sufficient security measures, and then can also put it on the track to open a formal investigation. That's what.
And obviously, this notification has been associated to a complaint.
As well. So the combination of the
by the data subject himself.
Okay, that's because the data subject is also informed normally about the data breach. Yeah. So he knows about it. So he at that time had also an extra complaint about that.
You're right.
And a very small add-on question. Did you also see that the CNPD has rejected already complaints where they have sent the complainant back to you in terms of, as you may recall, normally the data subject has first to exercise his or her rights towards the data controller, and it's premature to complain?
Unfortunately, we never have the feedback from CNPD after the complaint has been treated and processed by us. So we send our files, we send our element for proving what we done, and after we do not have any feedback.
Okay. Can I just ask to have maybe the second slide set for Mr. Zinner? Yeah. So what in the audience we have seen a lot of complaints, hundreds of complaints every year. Then it goes through the complaint mill, the filter, as you correctly said it. Then, of course, an interesting question is, what complaint files, what complaint cases make it to that next stage to open a formal investigation? We are aware, of course, that you are sitting already, you're responsible for that investigation phase, but what is your experience there? And can you tell something more about it? And then maybe a second question, stick to that. We have seen that, for example, the thematic audit for the DPO immediately leads to an opening of an investigation, where it would not be possible to get a thematic audit down to the level of a complaint procedure, which means that cases can also be closed more easily if you see that there are some minor non-compliances with the GDPR, that they can already be closed. These corrective measures mechanism before they make it to a real investigation. So
I'm going to talk first about the complaints which actually make it to the investigation phase, and I've got two specific aspects I would like to point out. I have actually prepared a short presentation. The first aspect specifically comes down to the structural organization of CNPD.
Yep.
So for you members who might not know how we are structured, just have a look at this. The point that's really important is here, where you see that the complaint department is actually functionally separated from the investigation department. So we both have direct reporting lines to the college, and but there are no direct interactions between those two departments. The second aspect I would like to point out is actually a legal and a procedural one. The first one being Article 38 of the Framework Law says that only a commissioner, as you actually said before, only a commissioner can bring a case to become an investigation. The same basically is said in Article 8 of the Rules of Procedure on Complaints, which you also mentioned before, which says that at any moment a commissioner can decide to transform a complaint into an investigation, but it needs to keep to the Article 38 procedure and goes through there. So the thing is, in the end, it will be a decision that's going to be taken by one of the commissioners. And as you also mentioned before, we have professional secrecy. What most people don't know is that we also have the secrecy of the deliberations, which means, for instance, me, I'm not part of the deliberation. So I'm not part in this meeting of the commissioners where they take those decisions. Basically, I'm receiving, or my department is receiving the investigation, and we are executing that one. So if you want a clear answer to your question, you actually have to ask one of the commissioners. Now, when it comes to the, you wanted to ask the second part of the question about if there are alternative manners on how to resolve problems.
Yeah, because in the thematic audit of the DPO, we have seen that there are sometimes remarks that are a bit maybe minor remarks, and that it can be that they can be fixed quite quickly, and whether it would not be just an idea, whether you would not be able to tear it down to the level of a complaint thematic audit, that you have a thematic audit that is opened with questionnaires, and then where instead of opening a formal investigation, that you can already close some cases where there are some minor non-compliances that have been established. If that would be feasible or an idea, because as we have seen in the DPO audit, then you have 25 cases that all have to run through the whole investigation. I think it's a lot of work for your service, and maybe in some cases, maybe not so. In cases that can be maybe closed more rapidly. Of course, there are some more serious cases, and of course, that's logic that you go on an investigation track. So, what are your thoughts about that?
So, actually, I would propose let's maybe first have a look at which different channels exist on how investigations could be opened. So, actually, I'm presenting here the frame of reference we have on compliance control. And you see that for the first ones, you have all the proactive ones. That's the ones you were talking about. So you have incidents, complaints, news, or even EU cooperation cases. But we are reacting to something, so there's a pre-existing condition. Yeah. While on the second part, once again, you see EU cooperation, but EU cooperation cases can be reactive or proactive. But the important parts are actually the parts of sector supervision, topic supervision, or actually follow-ups. So having that in mind, we are going to have a look at the proactive ones. what you want to talk about for the alternative measures. Procedurally speaking, you must note that actually the current version of the rules of procedure we are having, they are not actually giving a solution to that one, because there is no provision as to an alternative manner resolution for cases.
Okay.
So, hypothetically speaking, should it be possible to use an alternative manner resolution for those cases, I'm actually of the opinion that using the formal investigation is an extremely effective means for CMPD to make themselves heard. So, because on one hand, you will be able to check within a whole sector, or at least that part of the sector that's subjected to the investigation, like to assess the level of GDPR maturity. And you will also be able to enforce a very coherent position on an identical level for the whole sector.
Yeah.
The problem is that if you're going to go with alternative means, those are normally tailor-made solutions. And also, they probably do not receive the same kind of publicity as you do with the investigations. So the idea being here, you want to do something for the sector and not one for one specific entity.
Yeah.
So there's an interest of doing that. And last point, if you come to the follow-ups, or the re-investigations, you know that we can come and re-investigate the same problem. In order to be taken seriously, it needs to be investigation. If you're coming with alternative measures, nobody will listen to you.
Yeah, that's true. You, if we talk about it with lawyers in the field, they also ask themselves, why is not everything becoming actually an investigation in the first place? So you could also, but that's
that might be overkill on the other side.
That may be overkill because there are too many complaints, and then the priority would be even stronger, and less cases would make it, and you would get less GDPR compliance. So Stefan, turning to you. So we all know that, Post was one of the 25 lucky organizations to pick out to in the context of the formal DP audit. What was your experience there? If you see the procedure that we have explained, what was your procedure there in terms of collaboration with the CNPD? Because I also have to mention that Post was one of the ones who got out without any sanction.
Yeah, indeed, Post was, as you said, one of the 25 lucky organizations audited as part of the thematic audit campaign relating to the function of DPO. This audit started very earlier in our internal process to become compliant, because we were just started our program 1 year ago. Post is a big company, and we were not finished to implement our system, management system for data protection, so it was quite tricky. But indeed, the control began in September 2018. As many of the other companies, I guess, we received a preliminary survey questionnaire to which Post had to respond within 3 weeks. The engagement letter also told us that the preliminary investigation would probably be followed by an on-site audit or an interview on-site at the CNPD office. We were aware of that at the early beginning. To prepare for this phase, the CNPD asked us to prepare a list of documents as evidence. It was about 15 documents in order to be able to present this document during the audit phase in case of question by the auditor. For our case, the audit took place in February the 26th of 2019. Okay. So 6 months after the beginning of the preliminary phase. In the form of a visit at post office. So we had a
announced visit.
Yes,
so,
announced. Okay. We took a rendezvous in order to be able to manage people who has to be present in order to answer the question of the auditor, of course. So the CNPD team representatives were 3 people. Our commissioner, of course. At this time, it was Mr. Bushman, one lawyer, and one specialized IT auditor for any question about information system and cybersecurity. So the audit meeting where it took about 3 hours, as I remember. After this audit, subsequently, a visit report was drawn up by the CNPD and approved by post. So as you were talking about that, we had an exchange with the preliminary report, and we had to answer and to acknowledge all the preliminary conclusion. And then the draft inspection report was sent already to post, with also in November a proofreading and a feedback to the CNPD. And 1 month later, we had the definitive report. So we were lucky. There have been no subject of any breach noted in this report. I hope and I guess that it was all the preliminary job that we made in the company to be ready for that kind of exercise. So that's it. And it was a quite interesting experience. I would also precise that me as a DPO was part of the audit as a designated DPO, of course, and because of the matter of the control.
Directly concerned.
But of course, I was not the controlled representative.
Yeah, sure.
It was my boss.
Yeah, sure. And a very last question on a bit of a concluding note, Mr. Zinne. So now that you have seen that a lot of investigations took place, you have also a first retour d'expérience. Well, I think honestly, we know you already a longer time, and before the GDPR, there were already investigations going on. But what is now, in the context of the post-GDPR, the way of enforcement there, in the investigation phase, what is your first feedback there? What worked, what didn't work, and
Well, I would say that thanks to GDPR, the campaigns we did, and I would definitely say the headlines we had specifically over last year, it is safe to say that data protection has finally arrived at all levels of society. Specifically when we're talking about those 4 campaigns, you have talked about the video surveillance and geolocation tracking, we had the COVID, the DPO we just talked about, and the transparency campaigns. They have been very well received, in our opinion, by the public. Even we had positive feedbacks from the controlled entities, and they permitted us as CNPD to actually raise awareness in those specific places. You also mentioned before that that was a problem that was very specific for 2021, well actually 2020 and 2021. We were criticized for not having published decisions immediately. Just let me rectify, I have some very fresh numbers for you. So these are valid as of 31st of December 2021. We actually had taken 49 decisions so far. 30 of those 13 were closed, so no problems found. 36 were corrective measures. The total amount of the fines pronounced is of 746,327,600 euros. But, as we have said before, we have this one big case which has a record-breaking 746 million. So actually, what does that say for the other cases? We have 35 decisions for 327,600, which makes it about an average of 9,300, let's say 10,000 euros per case. Now, you cannot go around and say, yeah, that's what we're going to distribute. It's just an average calculated. There are cases where we have very low fines, and there are cases which were far worse where we had quite high fines. That was one of the conclusions I had to draw. And there was another point, a specific problem I wanted to actually signal, and it very often applies to banks, so I guess it will appeal here to the audience talking about it, because there seems to be some misunderstanding about some part of our procedure, specifically when we're talking about audit. Now, I know that they have a very serious level of maturity when it comes to audits, but the one rule we are applying, and that is different from standard audits, is we're actually making the inventory of non-conformities at the exact date of the investigation. So even if you're going to provide us later on with mitigation measures, but you implemented them after we have controlled, and even if all the problems we had found are being eliminated, there may nevertheless be a proposal to issue a fine. Most of the people think it will be like in audit, where you're presenting the measures and then you might drop the case in the course of the audit. That is not possible for us. So basically, the chef d'enquête will propose a corrective measure, and it will be later on the formation restreinte to actually take those into consideration. I always say to people, which we're talking about, it's like if you're being caught speeding, you will have to pay the fine, even if you're taking measures so that you're not going to speed in the future. And that is really something that's quite important. And actually, I brought you another part of the diagram when it comes to the diagram of on procedure, where you see this is on-site controls, but it's specific, the audits are not included in it. This is just for on-site controls. But what is important is we are actually in the first part there, where we are taking up to the date of the controls. But the decision later on is being taken by the formation restreinte that may take it into account. Now, one very important note, because I don't want the message to be, yeah, why are we presenting mitigation measures? We will take them into account when we're actually calculating the amount of the correctional measures or the fines. And specifically, the formation restreinte will do it. So, yes, please do present us with it, but do not expect at that stage that it will just go away. And you also asked me about if we could provide like 2 or 3 pieces of advice very quickly. My point is, specifically pertaining to this, document, document, document. Document all your processing activities extensively. I'm not just talking about the register of processing activities, I'm also talking about reviewing contracts, review your information notices, update and review them regularly. Develop and implement a step-by-step plan or procedure in case there is an investigation. Yeah. Specifically designate some employees that are critical in an investigation. I'm talking about DPO, legal, compliance, directors, management, IT, and so on. And please do provide for backups. That's a thing we're seeing all the time. We're coming, we're having an investigation, it's not announced, or it's an on-site control, and nobody's there. Now, I understand that's how life is, but at least try to provide for a backup. So, because we are going to proceed with the control, if the person is there or not. But we prefer if the persons who have the most of knowledge are actually present during the investigation. And then the last point I wanted to talk about is providing training to the employees and on data protection and on how to handle investigation if possible.
Yeah, thank you very much. That's a nice concluding note. So I hand over the floor to Peter.
Well, nothing much to add apart from thanking the speakers. I think it was very clear, and the audience as well thought it was very clear because we had no questions. So just let me say thank you very much for this very clear presentation. It is really useful to us. Thank you.
Thank you very much.
Thank you. Bye-bye.
Bye.
Bye.